Court calls the case People versus Shauna Stump.
Welcome to today's case, and buckle up because Judge Simpson wastes no time when dishonesty creeps into his courtroom. This is People versus Shauna Stump, and what starts as a seemingly simple bond violation spirals into a tense back and forth of excuses, contradictions, and outright admissions of lying. You'll hear a defendant try to dodge responsibility, a defense attorney scrambling to salvage credibility, and Judge Simpson delivering blunt reality checks that cut through the noise. We're going to break this case down piece by piece, the legal stakes, the emotional breakdowns, and the subtle details that reveal why credibility is everything in front of a judge. Think about it. How far would fear push you if you were facing a judge with this reputation? Keep that question in mind, because as we move deeper into this case, you'll see just how fear and deception collide in real time.
Thank you, Your Honor. Assistant Public Defender Qasim Bilbasi on behalf of Shauna Stump, who is present to my right. You can state your full name for the record.
Shauna Stump.
Your Honor, today is the date and time set for PCC. At this time, my client is wanting to waive the right to a preliminary exam and seek an offer of 7411 at the circuit court level.
Well, except we have a problem. You have the violation report,
I do not.
Mr. Allen. He was ordered over to community corrections and has failed to report.
Okay, so this is what happened. So I was PR bonded on last Tuesday meeting or afternoon, I guess. Well, nothing ever got sent over to the courts or to the jail. So I didn't have any paperwork to leave with or anything. So I had to call up here after I got let out, finally, after whoever was at the jail working at the time had figured out what was going on with the case and my bond and everything. I had to call up here on Thursday to find out what I needed to do. And all they told me was I had court today. That was it. And they told me at 9 and not 1. So
Your Honor, if the court is willing, I could have my client report to community corrections immediately.
Yeah.
I could walk her down there myself.
I do apologize. It was not intentional in any way, shape, or form.
He was to report to community corrections beginning June 20th for intermediate supervision. They tried to contact you by phone on the 21st when you didn't show up. Unable to make contact, your voicemail was full.
Yeah, I own a business, so probably was.
The voicemail excuse. This is where the drama gets layered. On paper, owning a business and missing calls seems like a minor hiccup. But in legal settings, perception is everything. The judge hears, "I didn't prioritize my court obligations." That's deadly. What's fascinating here is how Simpson zeroes in on accountability. The defense attorney tries to patch it over, but the judge sees through the pattern, excuses piling on excuses. Notice also the undertone of frustration. He's not just hearing a failure, he's hearing disrespect to the system itself. From a psychological standpoint, people under stress often over-explain or bring in unrelated details, like the defendant's talk about owning a cleaning company. But the more she talks, the shakier her credibility sounds. At this point, you can feel the tension. Will the judge give her another chance or slam the door shut?
So I'm very bad about deleting my voicemail.
I also had a conversation with her about that, Your Honor. I ran into a similar issue with her, so
if you do get tested, you're gonna come back negative for everything?
Yeah. No, I'll come. I should.
Yeah.
First Suboxone.
What?
First Suboxone. Yeah, I should. Well, no.
What?
Yes, sir.
Her baseline level would still show that she's
that I have
positive.
Yeah, for you.
But we're confident that it would be going down.
Going down, correct.
Are you in a program?
I am not currently in a program, no, sir.
So where are you getting the Subox?
Well, I'm not any longer, but I was.
Okay, so let's play the game. So when did you come out of the program?
I'm sorry.
When did you come out of the program?
6 months ago. I still have a valid script from a year ago.
This is the turning point. The judge pushes about her Suboxone use, and the timeline crumbles. She admits to being out of a program for 6 months but still has a prescription. That inconsistency screams red flag. Judges don't just evaluate facts, they evaluate patterns. And this pattern suggests blurred lines between compliance and manipulation. Simpson's frustration boils over because dishonesty in addiction treatment cases undermines trust, not just in her, but in the system designed to rehabilitate. The takeaway here: courts can forgive mistakes, but lying about substance use undercuts every ounce of leniency. Think about it. Should courts treat addiction lies as survival tactics, or should they come down harder to protect credibility?
Oh my God, I can't handle this right now. I'm gonna have an.
Really? Me either.
I know, I'm so sorry.
So here's what's gonna happen. I'll call her back out maybe, but I'm gonna let you talk to your attorney.
Okay,
So that what happens is that your attorney, I'm sure, will explain to you that the one thing, how you have to deal with me is you need to tell me the truth.
mhm.
And you're lying to me and skirting around a lot of the questions that I'm asking. You are. And you know you are.
Yeah, because I'm terrified.
Yeah, me too. So, Mr. Allen, you can take her, put her back into custody at this point.
Oh
We'll
my
call her case back up at some point. Mr. Obese, you can take some time to talk with her and
Thank you, Your Honor. We would just ask that the sentencing be pushed out so my client can get back into compliance. As I said, I'm going to be walking her over to community corrections as soon as we're done here. And she is interested in resolving this case, Your Honor. She wants to enter a plea of 74-11. I have the waiver here, the waiver of her exam.
so she wants to waive up and plead.
Yes, that's correct, Your Honor.
Well, how do I know that she's gonna get in compliance with this? Because she wasn't telling me the truth when she came in.
Your Honor, my client was, to say it in the simplest way, she was terrified, Your Honor. She understands that, you know, there's no excuse for her behavior. Like I said, she's admitting to the violation at this time.
And I do apologize.
No.
Well, what is she admitting to? Because she first of all blamed the jail. Then she blamed other people for not getting. So what is she, what's the true, what?
Your Honor, she's willing to take responsibility that it was on her to figure out what she needed to do, and she shouldn't have waited for somebody to send her paperwork. She should have gone over to the courthouse, gotten the paperwork herself, gotten everything she needed, went to community corrections. She does want to rectify the situation, Your Honor. We do want to fix this. You know, if the court deems additional testing, my client is open to that as well. So we will leave it to the discretion of the court, Your Honor.
What do you do during the day?
I clean houses, Your Honor.
The shift here is fascinating. After calling out dishonesty, Simpson pivots to daily life questions: work, routine, structure. Why? Judges probe lifestyle to measure stability. A cleaning company sounds responsible, but paired with dishonesty and failed reporting, it feels hollow. What Simpson wants is proof that the defendant can manage responsibility beyond courtroom excuses. This is where defense attorneys often highlight employment or family ties to argue for leniency. But here's the tension: do those claims outweigh credibility gaps? It's like building a house on shaky foundations. No matter how good the paint job, cracks still show. This line of questioning is Simpson's way of testing whether she's worth trusting again.
I actually own a cleaning company, so. Yes, sir. I know, I've
You're gonna
grown but one.
order, but
Helps, but
a new order. But we're gonna not do it quite that way. With the urine ET, it's intermediate drug testing urine and ETG 2 times per week. Ma'am, you're going to waive your right to a preliminary examination,
Yes, sir.
and you understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it. You understand that you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on a single charge.
Now we hit the legal pivot. The preliminary exam is waived, moving the case to circuit court. For non-lawyers, this means skipping a stage where the prosecution must show probable cause. Why skip? Strategy. Waiving can signal the defense wants to negotiate quickly, avoid more exposure, or angle for a plea. But here it's also damage control. The defendant already admitted violations, and prolonging scrutiny risks worse fallout. Simpson's skepticism lingers though. You can hear it in his tone. He's essentially saying, why should I believe compliance will suddenly happen now? Audience question. Do you think waiving the exam was smart strategy, or just a desperate move to buy time?
Yes, Your Honor. Thank you. We would waive formal readings and stand mute to the charges at this time.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea. Pretrial will be set for well, give me the out date.
It's August 12th at 1:30 before Slay Monday.
August 12th. But what is the other date?
The other day would be July 8th at 1:30.
August 12th.
Yes.
Pretrial will be August 12th, 2024, 1:30, Judge Slay,
Monday.
Monday. You admitted to the violation of bond, and her bond will be continued as previously said. I'm going to enter a new order that she'll have to comply with. Anything you want to say before I sentence you on the violation?
No, just I apologize, Your Honor, for not being honest.
I don't even know why you did that.
I don't either. I'm old enough to know better, honestly. So,
I really don't. I don't understand why you came in here. You're lying to me, you're lying to your attorney, you're lying to everybody.
I mean, I'm lying to myself. So I understand, Your Honor, and
Well, I always tell people, I'll deal with the truth and we can deal with each other when it's that way. But if you lie to me,
yeah,
that's
difficult.
That's going to be the bigger problem.
This moment encapsulates Judge Simpson's entire philosophy. Lies are the ultimate violation. Courts can work with almost anything: addiction, poverty, missed deadlines, but they cannot work with dishonesty. His blunt warning isn't just for this defendant, it's a lesson for anyone watching. What's powerful here is the humanity. He admits he'll deal with the truth even if ugly. It's not about perfection, it's about honesty. From a legal analysis standpoint, this line becomes precedent for sentencing decisions. Simpson effectively says, tell me the worst truth and we can work with it. Tell me a lie and I'll bury your credibility. Viewers, how do you feel about this? Is strict honesty always the best survival strategy in court, even if it means self-incrimination?
I understand.
So the sentence on the violation, defendants to serve 5 days, Washtenaw County Jail. Defendants remanded. Time served. What, for back there for an hour or two? Seriously? And Bill BC, if you had said yes, I would have come off the bench and you're straight.
I did say.
Yeah, okay, man.
I told her we'll talk after. That's it for me.
Oh, it is.
It's always wonderful being in your courtroom.
Yes, you ended on a fine note. Take care, sir. Court does call the case of the people versus Robert Jones.
Assistant Prosecuting Attorney Morgan Barroso on behalf of the people. Good afternoon, Your Honor. William Amadeo, P76194 for Robert. Robert, please state your name for Judge Simpson, his staff, and Prosecutor Barros know it is you.
Robert Louis Jones Jr.
First of all, Your Honor, thank you for hearing this motion. I'm taking over this case. I know you and your staff read everything, and I wrote in detail about this man. I wouldn't represent somebody who would disrespect your court, Judge, and clearly he dropped the ball here. He dropped the ball in a bad way. But the life he's led is admirable.
Whoa. Really?
His history.
Okay. Mr. Amadeo, because I trust you and I believe you, I want to be sure you know what happened during the trial in terms of the evidence that came in.
I understand, Judge.
Which part do you understand?
I understand that this case never should have went to trial.
No, he's entitled to a trial. You also know me. I'm just going to be real. You're telling me, and I know you're telling me in good faith, that this is somebody admirable, and I'm not going to punish you for this. But a woman writes me a letter that there is this committed partnership that he's in for the last 7 years. Right?
Yes.
During the course of the trial, it was about a woman who he was involved in a supposed committed relationship for almost 3 years. If that's not bad enough, what led to the entire dispute was because he took some other woman to the movies, and got seen by somebody. So I'm not saying it's falling on deaf ears. I'm not, but I don't know that somebody can start out saying this is an admirable guy. I mean, maybe that's people's standards. It's not mine.
Well, if I could try to clean up the mess.
I don't know that your broom's that big, but go ahead, take a shot.
His partner, who's an amazing person, is in the court today, and she's going to be stronger than any probation officer would be. She's heartbroken over this. I understand what came out at trial, and I understand how you were disrespected. But I also understand, if I could at least argue this point, and Judge, I understand you're the boss here, but I have to advocate.
Go ahead.
I get that, Judge. He is a great father. He's a hard worker. He had no previous criminal history for 20 years. I'm not asking for a gift. I'm asking that he goes on tether and house arrest just to be able to support his daughter. If I was on this case, Judge, things would have went a different direction. I'm not trying to throw anybody under the bus, but I do have control of this man. He is humbled. He has been given a major wake-up call. I ask you to consider all those factors when you render your decision today.
All right. Can I just say one other thing? It wasn't even so much about, it wasn't about disrespecting me. I think you need to also understand that part, because I don't know what he told you. But it was what he was doing during the course of the trial to the victim while she was testifying to victim one, the one that he was involved in, and then her sister. And I watched him the entire trial. And if his eyes could have ripped. Is he okay? Because if he's not okay, they could take it back.
I'm fine.
Are you okay?
Yes, I'm okay.
Okay. Can he sit down, Judge?
Yeah, he gets it. No, I'm not. You're gonna have to take him back, because I don't know what's going on with him. Because I'm not. He's not. He just fell a second time. This is Thursday, Friday. What do we have now? What I would do, I'm not going to proceed with this motion without him, but I don't think he's in. I don't know what's going on. So I can hear it tomorrow. I can hear it Monday. I can hear it whenever.
Is there any way tomorrow afternoon would work at all?
Like I said, I'm here, but I'm not trying to force anybody to be here. I don't think any of us expected this to happen. So, I mean,
For not, I haven't had a prep day in about 3 weeks.
I don't know. You've been doing just fine without it. No.
Like to not work all weekend.
Oh, man. I'm sorry.
If we had to go to Monday, could we do Monday afternoon? Because
I am here literally all day on Monday, so whenever works for you.
what time would work for you, Judge, on Monday afternoon?
2:00. All right.
And if I were to revise anything in the emergency motion, would that be acceptable to the people in the court?
Well, if you send it to me and then, I mean, it depends on what the revision is, but I mean, I'll hear anything anybody wants to say. I don't have a problem. So I'll just adjourn this out to Monday is what, the 1st?
Yes.
All right, July 1st, 2024 at 2 p.m.
Thank you, Judge.
And that closes the case, at least for now. The defendant admitted to bond violations, received a 5-day jail sentence, and was bound over to circuit court. Judge Simpson made it clear dishonesty is non-negotiable. The legal lesson: compliance matters, but truth matters more. Emotionally, this was a case study in fear, excuses, and the heavy cost of lying under pressure. For viewers, it's also a reminder that judges are not just referees, they're human lie detectors with authority to act on instinct when trust is broken. Cases like this ripple beyond the courtroom. They shape how the justice system balances accountability with rehabilitation. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.